Our first panelist over here is Katya Curran. And Katya is the team lead at the Human Rights Information and Support Services team. And she's previously worked as a mediator at the Commission. And before that, she worked as an employment mediator in Aotearoa. And before that, she worked for peace building charity in London and studied philosophy, politics, international relations. She's proudly queer and a member of the rainbow community and lives with her partner and 2 cats. How cool is that? Very cool. Give her a hand. I was about to read up from the paper and lives with my partner and 2 cats and their partner. We've got our wonderful Adam over here, who's also from the Human Rights Commission as well. Adam's worked at the Commission since 2015 as a team practice lead of the Inquiries and Complaints team, and is now the Disputes Resolution team lead with the Information Disputes Resolution VOCU. He's an accredited and experienced mediator of discrimination and complaints who provides guidance to his team. He previously worked as an industry ombudsman under the conciliation and investigation model. He has a disputes resolution, law and social sciences background. He enjoys time with his young multicultural family in Aotearoa and overseas. Yay! Okay, and then we're going to, well, I was wondering, I'll introduce all of them and then we'll hand over to them and then they'll talk and then we'll open up for a Q&A. Our next panelist here is Riki Jamieson-Smyth. Smyth?
Doesn't matter.
It does matter, sorry about that. Riki manages the Investigations and Dispute Resolution Group at the Office of the Privacy Commissioner. She's been at the OPC since 2014, and each year her team deals with hundreds of complaints and thousands of inquiries about the privacy issues, all privacy issues under the sun. Riki is a practicing lawyer and mediator and appointed fellow of the Resolution Institute, and Riki is passionate about privacy, human rights and access to justice. That's so cool. I've never heard anyone say they're passionate about privacy, but I love that. It's what it adds together. It's amazing. I'm proud to introduce my friend Michael Timmins, pronouns are he, him, and Michael is the director of the Human Rights Proceedings. He's from Tamaki Makaurau and has over 20 years of legal practice both here and abroad. He's an expert in international human rights with a particular interest in refugee rights, and his overseas experience includes working with non-governmental advocacy agencies, the UN, and in academia. And as a director, Michael firmly believes in important access to justice role in that his office represents. And also on top of that, if he couldn't be cooler, he's actually got a Samoan wife as well. So how many people get us together for that as well? So thank you, Malcolm. And then we have very lucky to have all of our panelists here, and we're very lucky to have Peter Boshier, pronouns are he, him, and Peter is the Chief Ombudsman for New Zealand, Aotearoa. He was appointed in December 2015 following a distinguished career as a judge. And Peter was appointed as a district court judge with the Specialist Family Court Warrant in 1988, and in 2004 he was appointed as the Principal Family Court Judge of New Zealand. He's also served as a Law Commissioner and served on government's Family Violence Task Force. And he has a long association with Pacific judicial issues, and in 2000 he was bestowed with the Samoan Matai title of Misa. It's very cool. That's actually why Peter's here today, because of that association to Samoa. As Chief Ombudsman, Peter's focus has been on faster and more effective resolution of the Official Information Act and complaints, and working with government agencies to improve their practices and strengthening his team's investigation and monitoring of prisons and public mental health facilities. And after serving as the regional President of the International Ombudsman Institution Australasia and Pacific region, Peter was elected second Vice President of the Institute in 2022. So we've got a lot of wealth of knowledge here and experience on our panel today. So the way that this is going to go is that each of the panelists in the order of sequence, so we'll start off with Human Rights Commission, then the Privacy Commission, then the Office of the Human Rights Proceedings, and then the Chief Ombudsman, that they will present for 7 minutes. After that, they'll do a Waiata and they'll also do a dance. What they'll do is they'll give a preview, an overview of the services that are often how you can access these services as well. And then after that, we'll open up for a bit of a Q&A from the team. Okay, so we're going to get right into this, and we're going to hand over to my colleagues over here, Katya and Anne. And they've got a little bit longer because there's 2 of them representing our organisation. So that's just going to be about 1 hour. No, just kidding, 10 minutes. Okay, hand it over to you.
Morena koutou ko Katya aho. I just wanted to start by saying that when I walked in here, I said to Tane, probably everyone else I saw, it was just so beautiful to walk into a room full of so many tāpuri and queer people, and it was overwhelming in a really beautiful sense. So really honoured and happy to be here this morning. So I'll try to keep to a short time and not go too much into the details of the legislation, but I just wanted to give a bit of an overview as to the legal framework that we'll work under in Kāhui Uenuku Tangata. So we have collectively, as a commission, we have a really broad role, I would say, to advance human rights in Aotearoa. But what everyone might not know is that the focus of the Act, I would say, maybe I'm biased, but the largest portion of the Act is actually covers discrimination, anti-discrimination provisions, and it makes certain things unlawful in Aotearoa. So alongside outlining what's unlawful in terms of discrimination, it also sets up our dispute resolution function. So our inquiries and complaints handling function is what we'll focus on today, but just be aware that other parts of Te Kāhui Uenuku Tangata do more advocacy work, campaigns and front-facing work. We are, I would say, the portal to the Commission, or the front door to the Commission, and engage with over 5,000 people every year. So collectively, that's a large chunk of Aotearoa. So discrimination effectively is different treatment based on a number of personal characteristics. So the ones, Adam might talk a little bit more about this, but sex, gender, sexuality are all protected characteristics. But I'm also aware that rainbow folk may also experience discrimination that's not to do with being rainbow, so just be aware that there are other grounds as well, age, disability, family status, marital status, etc. Aside from that, kind of the anti-discrimination provisions, we also have a broad mandate that's around social cohesion, fostering harmonious relationships, I guess raising awareness about te tiriti and human rights in Aotearoa. And that is a function that we're expanding at the moment. So I guess my main message is that we are always open and to flexible and creative solutions to issues that people are facing in Aotearoa, so don't hesitate to contact us. We're not limited, we're not that limited by the legislation in a way. So any human rights related issue that you're hearing, we can try our best to help with. I noticed on the lanyard on the back there are actually the contact details, so that's really helpful to whoever organised those. That's how you can contact us, lots of different ways. And just so you're aware, when you contact us, you'll hear from one of our friendly advisors, either over email, over the phone. And I did want to just throw in there that we happen to be quite a queer team. So there's a high chance you'll be talking to a queer person. But all of our advisors are very empathetic and really kind people. I would say, I'll just touch on, I suppose, one of our points of difference is that we're not particularly legalistic. We try to keep the door really open for complaints. And our kind of focus is to bring people together. So we facilitate conversations between whether it's communities or individuals who've been affected by human rights issues. Something we work about us. We're not sort of taking sides, we're not advocating, but we're really trying to enhance harmonious relations. Bridging divides, helping people find solutions. And one of the framings for this we use is that we help to move people from a state of morirere, unsettledness, to morinito, settledness. So whether we can actively help you find a solution with the other party, or whether we're actually providing information to help you solve your problem yourself or know where to get to, that's kind of our aim, that's our framework, and what each of us individually are trying to focus on. And through that, we provide an accessibility informed and a tikanga informed service. And high level, what that means is we try to create as much space as we can for you to let us know what works for you, how we should communicate with you, how we can make you feel more at ease, and that sort of thing. It's free of charge as well. So I'll give you just a few examples of real life situations that we've helped with. So just to show you a bit of the scope, A neighbour complained to us that their neighbour was being homophobic over quite some time, and so what we did in that situation is we spoke with the person who contacted us as well as the neighbour with their consent, always with their consent. We will never reach out to someone without you explicitly wanting that to happen. And conveyed the messages, conveyed the impact, and this resulted in a greater understanding and acknowledgement and no further complaints. Someone working in an organisation contacted us because there was tension between Takatapui folk and people of faith around sort of some of the visual messages that were being shown around the organisation. And so in that case, we didn't step in and tell anyone off. There wasn't anyone to tell off. It was often with rights, it's a balancing of rights. So our role there was kind of a conflict coaching sort of a thing. So to talk to the people who contacted us, get them to better understand their involvement, their place in this dispute, ways to go about it, and then letting them know that we're here if they need to come back for further support and guidance, or lead them to it to take that kind of information and empowerment on and resolve the issue themselves. There are many other examples. We can help you write a letter to another organisation, or we can actually facilitate a conversation in the room with someone else or online. And one other thing, last thing I'd mention is that sexual harassment is obviously a wide issue, not specific to our communities, but really important for our communities to know. It's not widely known that the Human Rights Commission actually offers a civil process for complaints of sexual harassment. So as we know, there are huge problems with going through the criminal system, obviously appropriate in some cases, but just so you know that we also offer a process, a mediation process for those kinds of complaints. If you're unsure, please contact us. I'll be here tomorrow as well. Please ask me directly. I'm happy to give you my direct email address. I know it could be a bit daunting to ask a question in Q&A or even to contact an organisation with a complaint. So really welcome to contact me directly or to come through any of the channels on the lanyard, and we'll do what we can. And just know that your self-determination is really vital through our whole process for you. So I'll leave it there. Thanks for listening.
Tēnā koutou katoa, ko Adam Tokuiwa. I'm the Dispute Resolution Team Leader at the Human Rights Commission, which is the next step where someone's made a discrimination complaint. And I think I'll start off with my key message today, which is really to spread the word and contact us if you, whānau, or people from your networks feel that they have been discriminated against. We have a strong history of handling complaints from rainbow communities, and we are really here to help. So our team is made up of a group of friendly and skilled mediators, or kaimuhauranga as we call them. They provide a free and confidential dispute resolution service to help people resolve these complaints under the Human Rights Act. And anyone can involve an advocate or whānau if needed. Now, discrimination complaints are usually about unfair treatment based on grounds such as gender, sexual orientation, or sex characteristics. People can complain about other forms of discrimination too, such as conversion practices, which we'll hear more about this afternoon, and sexual harassment, like Katya has mentioned. The treatment must have happened in an area of public life though. So that's government, employment, education, the prison system, healthcare and businesses. So very broad reaching to say the least. So how do we help people when they come to the Commission? Well, we understand it can be really difficult to share very personal lived experiences. They may have been traumatic, for example. And for most people, it might be their first time accessing a dispute resolution service, and they don't know what to expect. So part of our role is to make our service accessible, safe, and to put people at ease. We start by not making assumptions and getting to know a person's needs, which is underpinned by manaaki, whakawhanaungatanga, and awhi. So being welcoming to people when they come through the door, and usually it is Katya's team that you will meet when you come through the gateway at the Commission. But then it's about establishing relationships within our particular role and providing support where we can.
We check how people want to be addressed, as to personal pronouns, for example, and how we can make the process easier for them, including tikanga and cultural considerations, which might be important for people coming in the door. The big thing about our process is that it's really flexible. It includes helping people to communicate through a mediator, and sometimes coming together in a mediation meeting. And mediations can be online, over the phone, or in person, karahi kite kanahi. One of the aspects that's important to our role, though, is that we don't advocate for any people. We don't investigate complaints in our process. We also don't decide if discrimination has occurred. That's the role of the Human Rights Review Tribunal, and you'll hear more about advocacy services with OHRP from the director here today, Michael. So instead, we aim to create a space where people can share their experiences, be understood and work together, explore and agree on solutions that are able to help them to move forward in a positive way. It really does involve people, I think, fundamentally understanding each other, respecting each other's experiences, even if they might not agree on everything. And now I'm going to share some anonymised examples that illustrate some positive outcomes people have achieved in our process, which have benefited them individually, but also have resulted in systemic change, so a benefit to many people. I acknowledge that these examples are not the full prism of discrimination experienced by rainbow communities, but they do show who's currently accessing our services. So the first example is a trans student complained about challenges they were experiencing in school. Through our process, there were systemic improvements, with guidelines being developed to support all students, covering the wearing of uniforms and using changing rooms for their gender. The school also had widespread training on diversity and bullying prevention. The second example, a trans and queer employee at a restaurant, and this was a franchise, complained of hostile comments about their gender and sexual orientation in the workplace. The outcomes included monetary compensation and systemic improvements to internal policies and procedures, diversity training for all staff, including senior managers, and establishing support networks for staff. The third example, a trans person was able to wear their uniform choice and makeup in prison. There were also changes to improve their safety. I'm getting through my examples, don't worry. A gay couple had their child's birth certificate amended to recognise the child had two mothers. And this is a systemic change that benefits all gay couples. A gay couple were turned away from a hotel once the owners recognised their sexual orientation. The couple received an apology and compensation. So that's just a quick snapshot of our mahi and what people are able to achieve in our process. And I do want to have a shout out here to Tane Polkinghorn for his expert advice that he provides to our entire rōpū about rainbow communities in general. Thank you, Tane. Tane.
Tēnā koutou, tēnā koutou, tēnā koutou katoa. No airana, no kotirana oku tupuna, he tangata tiriti, he Pāngia au. E tipu aki au kirikiri roa I raro I te maru o Paupiri I te taha o Waikato awa, kei te whanganui tara, taku papa kainga, ko Riki Jamieson-Smyth, taku ingoa. Ko o te kai whakahaere, whakatauraru hoki ki te mana, matapono, matataupu. Ko tēnei taku mihi ki te tangata whenua o te rohi nei ki te ahiwaru. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Kia ora, my name's Riki and I work as an investigator and mediator at the Office of the Privacy Commissioner. My pronouns are she, her, and I'm a tall, white, cis woman. I'm wearing red lipstick and leopard print because I'm from Hamilton, and a black blazer because I'm from Wellington. Thank you so much for the invitation to speak to such a wonderful and diverse audience and with such learned and respected co-panellists. So the Office of the Privacy Commissioner has quite a limited jurisdiction in that we oversee the implementation of the Privacy Act in New Zealand. It governs how agencies, all agencies, can collect, store and use your personal information. So in broad sense, it makes sure that you know when your information is being collected, that you know that your information is being used and shared appropriately, that your information is being kept safe and secure, increasingly important in this age of a data breach happening every single day. And also, most importantly, really, that you can get access to your personal information. There are also codes of practice for specific sectors, such as credit reporting and telecommunications and health. Health is very important. So personal information is anything that's about you. At a very basic level, it's your name, but it's also your name, your face. Biometric can include the way you walk, your fingerprints, your address, anything, your contact details. I've got a whole list up there, but anything that can be used to identify you, even if you are the only person who can identify yourself from the information, and in any form that it's being held, and that can include in a person's mind. So there are 13 privacy principles that govern the life cycle of the ways in which personal information can be collected and held at an agency. Really important, I think, for our takatapuhi community is around the collection principles. Lots of agencies in this kind of new era would love to know about your gender identity or your sexual orientation. But do they need to know? Because once they have that information, they're only allowed to use it for really limited purposes. Plus, once they've collected it, they've then got to keep it secure from inappropriate disclosure. So my team is a team of 12 incredibly disciplined and hardworking individuals. And between us, with the help of a call centre answering our 0800 line, deal with sometimes up to 9,000 inquiries and 900 complaints a year. Of those, we try and pick up the phone as often as we can. So if you have a complaint, our first instinct is always going to be to get on the phone and try and help you sort it out at the lowest possible level. Unfortunately, sometimes a full investigation is necessary, and while we do offer conciliation and mediation, sometimes you just need a legal opinion to tell an agency what they've done wrong and what they need to do to rectify the situation. We're really good at that though, and in 2023 we had a nearly 90% settlement rate. I should say there as well that if we are unable to resolve a complaint, you are able to pursue your complaint to the Human Rights Review Tribunal, which I'm not sure if you've, oh well, Michael will talk about that. And for the very worst complaints that we're unable to settle, where there's been significant harm, we can actively refer the matter to Mr. Timmins over here, and he then will step into your shoes as the aggrieved individual, the tribunal, and provide you with expert human rights litigation advice. So the key things that we see in complaints to our office are generally about people not being able to get access to the information that agencies hold about them. This is just such a basic and key human right, because how can you know what decisions an agency is making about you unless you can see what they are making, what information they are making that decision based on, and also have the opportunity to ensure that it's correct. Unfortunately, and just lots of agencies don't adequately resource their privacy team or their information management programs. Lots of agencies don't understand their obligations under the Privacy Act. There are many more kind of sexy and competing priorities. There are challenges when you've got, 100 different contractors and outsourcing agencies who have their own obligations under the Privacy Act. And as I said earlier, agencies think, oh yes, that information would be useful to have, let's collect it. And people unknowingly will tick a box without knowing that they don't have to tick that box. You don't have to be handing over this personal information. So one thing that we're really looking at the Privacy Commissioner at the moment is how to move a focus away from my team into kind of proactive supporting of agencies to do better at privacy. And our key project for this year and moving forward is Pōpō Matatapu, which is a guiding post for privacy, helping agencies to do privacy better in the future. If you're interested in privacy, we've got a whole lot of free modules that you can access. They go from full suite, learn everything about the Act from A to Z. That'll take you hours and hours and hours. Or you can dip your toe in the privacy pool and do a 30-minute course and learn about your rights or your employer's obligations under the various Act and codes. So you can contact us either by contacting the 0800 line, or there are lots of methods of contact on the website. And my team are ready, willing and waiting to assist you with all of your privacy concerns. Done.
Oh, awesome.
I just think it's freaking awesome that we're doing a human rights conference there, Mātou. And I love the vibe of that. And I'm really pleased to be here. Just like Katya said when I came in the room, it just felt awesome to be around people who all want the same thing, which is just a better country, right? And I feel really supported to be here as a short, white, cis man. I also just want to acknowledge a couple of people. I know we've had a few acknowledgements already. I just want to acknowledge the people that have organised this conference. There's a lot of work that's gone into it, and I think you've done a fantastic job, so well done. Also want to acknowledge the Boren Foundation. I think that you guys are kind of disruptors in the philanthropic space in this country. We've got a long way to go in philanthropy in Aotearoa, and I think the work that you guys are doing is fantastic. And I'd really like to talk to you about a legal non-profit idea I've got. And it's only a few million, and so we'll talk. But I also just want to acknowledge one other person who's someone that I've always looked up to and admired, and that's Jack Byrne. Kia ora, Jack. Jack, I know a lot of the people in the room know about your mahi, and I know everyone acknowledges a lot of the work that you do, but I just wish New Zealanders knew about your international work. I think it's incredible, and I just think you're a genuine leader. So, kia ora, Jack. So I'm going to talk now about my team's mahi. We're called the Office of Human Rights Proceedings, which is an incredibly sexy and alluring name. We're lawyers, and our job is actually to take sides. And so we will look at people who come to us, and we will advocate for those people, and we will fight for their rights, and we won't apologise for doing that. And a lot of the time, we'll look at something that's come to us, and we realise that it's our job to say, hey, you know what? That behaviour is inappropriate. So we will draw a line on that behaviour, and we will get results for people who want results. So we'll do it within the confines of our system. And, you know, I wish I had more time to talk about the flaws of our human rights system in Aotearoa, because there's several flaws, there's several holes. And in this country, we like to pat ourselves on the back for being human rights compliant, but we've got a lot of work to do to actually make ourselves accountable to the human rights that that are inherent in this country, right? So there's two pathways to come to our work. The first pathway, which Riki's already mentioned, is we receive referrals from the Office of the Privacy Commissioner. And we'll take those cases on to the Human Rights Review Tribunal, and we will litigate them, and we'll try and establish and develop principles under the Privacy Act. Most of the cases we get under the Privacy Act, we actually end up settling, just like any other piece of litigation. We end up settling the case. But when we're doing so, we're always trying to get the absolute best result we can for that person whose privacy has been breached. I want to talk a bit more about our work under the Human Rights Act, because that's the 95% part of our work. And people can come to us after they've gone through the process with these guys. So after someone has made a complaint to the Human Rights Commission and it hasn't resolved for whatever reason through that process, an individual's entitled to come and apply to my office for free legal representation. And when someone applies to us, we have criteria under the Human Rights Act under how we assess that application. And basically what we're looking for is, what's the impact of this particular case? Is it going to have a broad impact on the human rights landscape in this country? Will it affect a large number of people? And also, is it likely to succeed? Because there's not much point in taking a case that's going to lose, right? But having said that, I do want to tell you that we're comfortable taking cases that we will lose. Because if it means that we're developing the law, if we're pushing the boundaries of the law, that's okay. Because there's also this thing called an appeal, and we will appeal if we need to, right? So we will look at the merits, but the merits is not a determining factor for what we're trying to do. The most important thing is that we're trying to develop the law and to really push the law. I just want to talk about a couple of areas that are a particularly important focus for me and my team. The first focus is that every year we get a bunch of money from the government and gets fed to us through the Human Rights Commission. Sorry, I should say my office is, we sit within the Human Rights Commission, but we're independent of the Commission. So the government gives us this bunch of money, and we want to use that money to sue the government. And we want to hold them accountable. That's a really important driving factor of what we're doing. We want to bring in all of those wonderful human rights instruments that we see overseas. We want to bring them in through interpreting and developing the Human Rights Act, because there's a lot of fertile ground in the right to be free from discrimination. How can we push that boundary more? And in this room, how can we bring in the Yogyakarta principles, this wonderful piece of soft law that deals with how we can interpret international human rights law and apply it to the rainbow community. And I've stood in front of Human Rights Review Tribunal and High Court judges, and I've argued you have to incorporate these principles into our law. And no one's agreed with me yet. But we'll keep going and we'll make it happen. So that's what we're trying to do. We're trying to push and develop that fertile ground. The other area that's really important for our office is sexual harassment. Because in this country, sexual harassment damages are a joke. If you look at us compared to other comparable countries, Canada, Australia, United States, how we value that intimate invasion of someone's dignity is pathetic. So we are really trying to develop and push that boundary. And when I took on this job, the highest award for sexual harassment damages was $25,000. Now we've now pushed that to 100. And what that means is that every other case since then that I've settled, we're getting up to those 6 figures, because none of the defendants want to be the next one who gets the higher judgment, right? So it does make a difference if we can start pushing these numbers. And my team and I, when we are now filing our claims, we're pushing those numbers up. We're not shy to do that. So that's a really important focus for my team. The other area that we have the jurisdiction and mandate to do is conversion practices. We haven't had one application yet, which I think is actually a good thing. But I just want to let everyone know that when we get an application, we'll take it. We'll take it and we'll push it on. And we will develop the law around that new piece of legislation. There are those exceptions there, right? And we want those exceptions to be interpreted as narrowly as possible and consistent with human rights law. And that's what we'll be pushing when we get our first application. So I want to tell you that we're here to develop and push that lane. So thank you so much for today, and I look forward to answering questions later.
Awesome.
Thanks so much, Marty.
Tēnā koutou katoa. Tēnā koutou e hui mai nei, ko tēnei te mihi ki a koutou katoa. Arā, ka haere tika tonu na mihi nui kia koe Elizabeth, me kia koe Louisa. Kei te mihi, kei te mihi. Ka tuku na mihi mahana no e mātou no tari o te Katya ki mana tangata, ki te whanganui a tara mea hoki tamaki makau. He rāwi kua tae mai nei a hau ki kōnei, ki te mihi atu kia koutou iti atana e pa ana human rights, the rainbow community, and how the Ombudsman can help. Nō re rā, kei te mihi anō. Talo whalava, mā lo e lelei, kia ora. Bulavanaka. I want to just, in my talk to you, cover 5 areas and do it reasonably quickly if I can. The first is a bit about the Ombudsman, a difficult word to pronounce and to remember. The Privacy Commissioner must be something to do with privacy. The Children's Commissioner must be something to do with children. What the heck is an Ombudsman? So it's a Swedish word which is gender neutral, and it means an investigator. The expression was born out of Scandinavia many, many years ago. We're the oldest in New Zealand outside of Scandinavia to set up an Ombudsman office, and last year it was 60 years. We started off probably with the most famous of our ombudsmen, Sir Guy Poles, who started in 1962 with a staff of 16 on the terrace. We now have a staff of 255. We're still based on the terrace, but also Shortland Street in Auckland. It's a very, very broad jurisdiction we've got, and I simply want to cover it in passing, but most people are astonished at just the breadth of work that the Ombudsman can do. I think it's important to say a little bit differently to Riki's job. My job is one that's called an Officer of Parliament, and there are three of us: the Auditor General, the Ombudsman, and the Commissioner for the Environment. The advantage, as Louisa and Elizabeth know, is that it gives us quite a lot of status because of our ability to directly report to Parliament and raise mayhem if we feel that something is unacceptable. In our own office, we've wanted to keep up and to lead. We have our own group called ORCA, which stands for the Ombudsman Rainbow Community and Associates. And this is our wish in our own office to try and lead by example. The second thing is, what do we do? Well, mostly my job is accountability. And that's really, really important for you in this room, because there are a lot of agencies and others in New Zealand that need to be held to account. And the Ombudsman was set up for that reason. And really what it amounts to is, if a complaint's made, or even if we want to look at something, what issue are you raising? What are the facts? What process has the agency gone through to deal with it? And has what they have done been reasonable or unreasonable? And that's where life is changing. What may have been acceptable and reasonable years ago is no longer. I'll give you an example, and it relates to te tiriti o Waitangi. When I was brought up as a lawyer all those years ago, te tiriti o Waitangi was not recognised as a legally important instrument. Now you disregard the treaty from the Ombudsman point of view at your peril. So accountability is really important. And for you, that is increasingly important. The third thing is, what do we do? Well, it's really to redress wrong. Katya ki mana tangata, guardian of the dignity of the person, the mana of the person. Michael talked about courts, which are really there to decide a case. We are there to see whether a process has damaged someone's mana and dignity. And we're most involved, not just with the end result, but ensuring that mana and dignity is preserved. And for you, that's really, really important. What we do if we find you have been unreasonably treated is, through quite a long process at times of investigation, form an opinion and make a recommendation. In the most part, the vast majority, agencies are too scared not to comply with our recommendations. They do not want to be on the front page of stuff. So our success rate, I think, frankly, is greater than it was when I was a family court judge, where I seem to offend 50% of the people most of the time. A little bit about the breadth of the work that, again, I hope will interest you, and our work in prison monitoring is important to the Rainbow community, because we've found time and time again, when we are in prisons monitoring and inspecting the Rainbow community, it's not just a matter of being not treated with dignity. Some of what we've heard from prison officers talking about the Rainbow community individualistically is just unacceptable. And that leads me on to this point where we're at in New Zealand. I know that although in this room here we have a liberal, understanding, dignified audience, but a lot of New Zealand is not like this. And I'm finding in my office, post-COVID, less and less tolerance, more and more abuse to my staff, and in some quarters, people are less and less understanding of others. So I think attitudes and trends are an important matter. Now, I want to just finish by talking for 30 seconds about the Official Information Act. That's a large part of my work, and never forget that this is a great means of accountability for government agencies and local government. If you feel that a policy is wrong, if you want to know why something happened, you want to participate in democracy, or you want someone who's made a decision to be accountable for what they've done, use the Official Information Act. And my office is the final arbiter of whether information should have been released or should not have been. Nō reira, tēnā koutou anō, tēnā koutou, tēnā tātou, pori noa, tēnā koutou katoa.
Thank you to Peter and all of our panellists. I know we've been talking for a while. We've got about 20 minutes for questions now.
Kia ora, Aokia Chelsea o Team Tukuringo. I had a question around privacy when there's a lot of our data is done overseas, and the companies overseas are using the data, so what can be done around that? And also sort of people with AI, how are there moves to be protecting the data there as well?
Okay, so when the 2020 Privacy Act came into force, well, I can just bellow if you like.
When the 2020 Act came into force, we got a whole new privacy principle, Principle 12, which
Prohibits the transfer
That's fine.
of information overseas unless the receiving country has the same kind of level of privacy protections as New Zealand. If it doesn't, if the receiving country doesn't, then the agency needs consent before it can transfer the information overseas. We work really hard at the Office of the Privacy Commissioner. We're an independent Crown entity, so we love to, hold the government to account too. But we work really hard with government to ensure that the privacy legislation and the controls that we have in place are comparable to overseas that have really high standards. For example, in the EU, they have the GDPR, which is significantly strong privacy protective legislation that applies across the EU. In terms of AI, the Privacy Act is technology neutral on purpose, and that allows us to be flexible and to respond to emerging technology that moves so fast that it's almost impossible for you folks, standard Wellington bureaucrat, to keep up anyway. Kia ora. AI is a technology that can affect the way that agencies process and use PI a lot quicker and more dangerously than before, but it is certainly something that braver minds than mine are addressing at the OPC right now.
I'm Kayla, I'm from Kāhui Uenuku Conference in Nelson. Adam and Katya, I had a question for you. I was wondering what the process is when the secondary party doesn't or won't come to the table to sort something out.
That's a very good question, because we do operate a voluntary process, but it's pseudo-voluntary in that what happens is if someone declines to participate in the process, despite us reality checking that around the possibility of it being referred back from the Human Rights Review Tribunal or Michael's office, they still have that ability to make that decision to say, well, I don't want to participate. But fundamentally, we do our best to kind of explain the risks of not participating and encouraging people's participation, because our process does offer people the opportunity to have some control and autonomy over how they participate and the outcomes that they want to achieve. So sometimes the outcomes can be really fulsome that you wouldn't get from potentially a court process. And Michael in particular has touched on the increases with sexual harassment amounts at the Human Rights Review Tribunal, and I'm aware of greater amounts being achieved in a mediation meeting. So it shows you the power of mediation, even if it is a pseudo-voluntary process.
If someone doesn't go to mediation, you should come to me.
Awesome. In some countries, sort of opponent groups use intimidation tactics to stop people from accessing their human rights. And I kind of feel like that Mike over there is doing that to us at the moment. So anyway, but we've got a question from the floor, and then we've got a really great question on the screen over here.
The diverse committees have been trying to keep Human Rights Act amended so we are included specifically. And it looks like we're going to wait the last 9 or 12 years. So how do we lobby and get that piece of work done? I don't know if you can answer, but it's really important.
Kia ora. Thank you for the question. Elizabeth can talk about trying to amend the Human Rights Act, but one of the things I wanted to raise for this room is the International Civil and Political Rights Covenant was a document from 1966, and the genesis of that document is the Universal Declaration of Human Rights from 1948. And Article 26 of the Civil and Political Rights Covenant lists the grounds of discrimination. And the drafters of that document were smart enough to know that they didn't know all the potential grounds of discrimination. So they had an inclusive list which included all other status. And that has been picked up in some countries such as Canada. The Canadian Charter of Rights and Freedoms talks about all other status, which has been fertile ground for human rights advocates to develop for further protections. And so sometimes I would just love it if we could just change our Human Rights Act, rather than having an argument every time the human condition is developed and matured, that we just say all other status so that we can try and protect people immediately. Now, I'm not naive. I know that politically that's a very difficult conversation, but it does seem to me that if a country like Canada can do it, I'm not sure why we can't.
Thank you, Michael, and thanks for the question. And I just wanted to give a bit of a shout out actually to Professor Claudia Garangia, who's here, will actually do a presentation later today on that very question, which we know our community is asking. So conference organisers have really gone out of our way to think about what are the hot, live human rights issues that are happening in Aotearoa at the moment, and to bring those speakers in. So thank you for being here as well, Claudia. Just want to acknowledge you. Peter, we have got a really great question for you on the screen, which you've read, so I'll hand it over to you if that's okay.
Kia ora, Andre. Look, whether there is a referendum on the relevance and place of Te Tiriti or Waitangi doesn't much interest me, and I keep out of politics because that's my job. But my job is this, and that is fairness and reasonableness to all New Zealanders. So my job will be to look at Te Tiriti or Waitangi, which was the forming of our partnership between tangata whenua and European, and to apply it in a way which gives equality and fairness to New Zealanders. So really, whatever the courts do or Parliament does, my job is to ensure, irrespective of any referendum, that equity prevails. And I want to give that confidence and that assurance.
Thank you so much. And one of Peter's earlier comments was just to say that after COVID, that they had seen at their office sort of a spike in what we might call the fraying of social cohesion in New Zealand. And so you may not know this, but under the Human Rights Act, that we have a mandate as a Human Rights Commission as well, not just to receive complaints, but also to try to provide the grounds and the space that we can encourage harmonious relationships between all the groups that call Aotearoa home. And so that means that when we start to see a spike in terms of harmful speech, there's another presentation tomorrow which we'll see, we have a real keen interest in that. Because what we want to see is that Aotearoa, everyone that calls Aotearoa home feels like they belong and they can be seen. So we have that sort of conciliatory role and leadership role that we also play as well. You didn't know. Okay, so the question here on the screen is, are there limitations to accessing these services based on visa citizenship status? Maybe a question for you, Adam. Katya? Yeah.
So in terms of the Human Rights Act, there are prohibited grounds that prevent people being treated unfavourably because of their national origin or ethnic origin. And what I must say, though, is that there are some restrictions. And one of those restrictions is complaints involving immigration issues. There's a section in the Immigration Act, Section 392, that limits our ability to provide dispute resolution services for complaints that relate to essentially visa applications, these type of situations. There's also a savings provision in the Human Rights Act that does allow central government decisions to treat people that are New Zealand citizens or British citizens differently from other citizens. But that's seldom used in my experience.
In terms of the individuals in this room and people you know, we wouldn't want to discourage people from coming to us because they have a different visa or citizenship status. We always try to take an open door approach, and it may well be that we can help them. And the other thing I'd just say, just in case it's unclear, Adam spoke on the areas of public life, education, employment and that, but the Section 5, the broader human rights kind of mandate that we operate under means we can do more than that. It's just a slightly different, there's the pathway that goes through mediation and the tribunal by Michael, hopefully, in many cases, but then there's also just kind of open season to try and help people. So don't be put off by some of those limitations. And there are also this kind of, even in cases of immigration, when we can't offer a dispute resolution process, we may be able to cooperate with other teams, commissioners, the legal team. Sometimes we've written with their assistance letters to ministers, highlighting the human rights issues with a particular policy and encouraging them to change them.
I just might add something there, that visitors to New Zealand that are here on a temporary basis still have rights under the Human Rights Act. So regardless of if you are a visitor, a student, for example, in this country, the Human Rights Act still applies to you. You still have rights under that Act. It's not that you don't have access to those rights. It's more situations where there's been a problem with a citizenship application or immigration application, and the implications of that are that we have a limitation to the dispute resolution service, but as Katya's touched on, there is that broader function that sometimes can be drawn on.
Thank you. Awesome. One of the things I'm hearing as I'm just listening to you is that, we've got a lot of really smart people here in terms of talking about different parts of legislation and law, but don't let that stop you. I think the key message is if you think that there might be something there, if you are concerned that your human rights in some way are being infringed upon, make the phone call, because hopefully what you're seeing on this panel are people that want to help and can guide you through some of that, even if they might not be ultimately to help you, that they want to make sure that there's less wrong doors to go through. We've got a couple more questions on the front. So over here, in terms of access, and all of our panelists can answer this briefly. In terms of access, what work has been done to share and promote your services to culturally and linguistically diverse communities, or CALD communities? We'll start off with you, and then we'll pass the down.
We know that we are limited in the ways in which we serve culturally and linguistically diverse communities, and that's a matter of historical issues and also the fact that we're very poor. We have an obligation under the Privacy Act to take cultural perspectives into account, and there's a real focus, particularly at the moment, on particularly being a good partner under Te Tiriti, and we have a full-time permanent pōarahi. We put a lot of focus on te reo and, acknowledging and reaching tangata whenua whenever we can, and doing that in a profound way, not just kind of going to Māori and asking them, like, what do you need from us? Like figuring that out and making it a two-way conversation. And then we have all the bog standard central government things that we can translate into almost any language. We can have phone from our 0800 number, any kind of language that you need. And we're very responsive. If anybody tells us that they'd like to hear from us, we will do our very best to make ourselves available to you in a way in which is useful to you.
Kia ora. I'd also like, with your leave, Andre, just for 30 seconds in relation to the last question, to say that your status is irrelevant if you want to use the Ombudsman, which, by the way, is a free service. So not only do you not have to be a citizen, we don't need to inquire, and frequently complaints are given to us from outside the country. The other thing just to say was the importance of whistleblowing and protective disclosures. I've got a complaint at the moment by 6 people who wish to remain anonymous, and they think that a manager in a local government is misusing his position for his own benefit. They think that's a serious wrongdoing, and I'm permitting that complaint to come through anonymously because a lot of you will be worried about retribution. Now, to answer this, a really, really good question. We are doing a lot in this space. It so happens I've got Dexter Trail, who is the kaiwhakahaere of my Roku Māori Hanora Hapori team. But in terms of the disability community, we have our own team called Te Roku Kaiarahi Oatanga, and most of the people on my team have a lived experience of disability. So we are using sign language often. We translate most of our work. In about a fortnight, I will release a report on extreme weather as a result of visits throughout the top of the North Island, and the whole executive summary will be in Te Reo Māori. I think that we have to give a lead. We have to be appropriate not only to our Asian, Pasifika and Māori communities, but also those who need assistance to access information, in particular deaf, blind, and those who find it difficult to otherwise access information.
In terms of access, I think the Office of Human Rights Proceedings has a lot of work to do. I'm just going to assume that most people have never heard of us. Is that fair?
I have.
And I think that's a real, that's a problem, I think. And we're a small team, there's 4 of us, and we're taking cases across the country. So we have that resource limitation, and we tend to lean on the Human Rights Commission, Te Kāhui Tangata, to help us with our engagement. But we've targeted as a team that we need to improve our access to different communities across the country. We do provide interpreting services, and we do act for clients from different linguistic communities, so that is something that we can work on. The other thing that we're trying to do is we're trying to provide access through our casework, through the work that we're actually doing. And so last year, we took a really fascinating case where we sued Television New Zealand to provide more simultaneous translation of the election debates and of issues of national significance. So, for example, COVID briefings, earthquake briefings, and so on, where there's a sign language interpreter provided by TVNZ. We said they had an obligation to do that. And that was that case was 4 weeks in the Human Rights Review Tribunal, and it was broadcast live on the internet with simultaneous translation of the case, so the deaf community was able to access that, which was the first for the Human Rights Review Tribunal to live stream one of their cases. So we were proud of that effort. But I just want to acknowledge that I think we have more work to do.
Yeah, same as Michael. I think we have a lot more to do in the share and promote your services front. And that's one of our big focuses for the coming year. But I'll leave it there because I see there's quite a few more questions.
So much. We'll just probably take one more question from the floor. From the meeting, rather. What advice would you give to public servants who are concerned about policies or practices being changed, developed, and implemented by the government of the day? So,
Make a complaint to the Human Rights Commission or any of us, depending on the nature of that. I think that's the key thing, to reach out, and then from there we can have a look at it potentially. Where there is some form of change in policy or practice that is of a discriminatory nature, we can offer our process for complaints about government ultimately.
Yeah, it's slightly tangential, but it's just been on my heart and mind lately. Just, I suppose, a reminder in this, the comments in this panel even have have brought it up again. There are so many different roles in a movement for social change, and I've just been thinking about that so much. You know, there are activists, there are frontline people, there are advocates who are taking a side, there are mediators who are trying to bring parties together, there's bridges, you know, there's people who talk to their whānau members quietly, there's servants, there's healers, there's therapists. So I suppose that's just something I'd share, to be gracious with each other when other people display a kind of different role in the movements that we all fight for. Kia ora.
Thank you. We've got maybe a question or maybe a comment from Ambassador Ward. So, listen.
I'll speak loud.
Okay.
Tēnā tātou katoa. Can I thank the panellists? It's nice to know that we have people formally in our public goods system who are there to support our needs and aspirations. But what's really struck me is it relies on individuals to come forward. And our individuals who, in coming forward, have to be incredibly vulnerable. They have to relive abuse and trauma. And I'm not saying that's not a positive, but I'm actually wondering systemically how each of your organisations enables more of a systemic approach and that it's a proactive engagement, but also the assessment that you've each made about the impact of the public service not meeting the needs of the Tākatākui community, and actually actively identifying issues that need to be resolved without requiring us to come forward and say we've got a problem.
Thanks, Elizabeth. Point taken. We have an ability to self-initiate and have done that on a few quite celebrated occasions. The first one was in relation to the uplifting of Pepe by Oranga Tamariki, and we looked at 78 cases in the course of that investigation. That was not as a result of a complaint, but our concern what was occurring. The most recent is Kia Whaitaki, and look at the prison system, which is the biggest investigation we've done so far. I think it is my duty to always be looking out for issues that are arising that I want to look at and not wait for people to complain to me. I regard that as absolutely pivotal to the role I've got.
Supplementary.
Given that I'm going to present Georgina's Waitangi Tribunal claim, which is the Tākatākui health claim, which essentially will highlight that there are no Tākatākui specific services, that there's discrimination in the health system, and unless we are providing these services for ourselves, then our needs will never get met. Now, I would have thought generically across the public service, who's the leading government department that's looking after our needs? I mean, I think there's already a justification for a report by your office, to be honest. And if that's one of the outcomes of you being here, that you do initiate and do now scrutinise how every single government department is meeting the needs of us as citizens, obviously supplemented by the census, but then we'll have some actual numbers. But if you go look at the University of Auckland survey, we know now probably 10% of us are sexually and gender diverse. There's already, I believe, a rationale for somebody to hold the public service to account for not meeting our needs.
Louise, I just want to say the Human Rights Review Tribunal and the High Court were wrong when they determined you were Fairfax kids. So I'm trying to challenge that currently, but I probably can't talk about it. But one of the things that my office is trying to develop is this concept of strategic litigation, where we're bringing cases on behalf of big groups of people. And so right now, the main case that we're trying to do that is in the disability space, where we've done the TVNZ case, which is about hopefully bringing more sign language interpreting on our screens. But the other one that we're doing is we're acting for IHC, where we're suing the Ministry of Education to say that the education system discriminates against disabled learners. So that's a huge case that we're taking, and that case wasn't created by us, but it was created by the non-profit community seeing a need and trying to bring together a complaint on behalf of its constituents. And I do see a space there for non-profit organisations to to do some of that lifting, and then when it comes to us, we can take lifting over as well and share some of that burden. So I have been having soft conversations with some NGO groups about potential strategic litigation, but we're always interested in more. And I don't mind being accused of being an ambulance chaser. It's just about getting the right cases out there to develop the law. So,
just to touch on Michael's point that even at a dispute resolution level, there are often instances where maybe an advocate for a community might come forward, not necessarily the person affected, that can bring the complaint on behalf of a group of people. So there is that flexibility in that respect. You know, we wouldn't close it down in any shape or form, acknowledging that, you know, people are coming with their lived experience and might find it very difficult to share that in the context of our process. And I suppose the other aspect that I kind of need to mention, that the Commission isn't represented here on the broader functions. For example, Andre's team, that does have an advocacy element associated with that. And that is proactively focused as opposed to the more discrimination aspects associated with the Human Rights Act and ultimately the narrow focus. Put your hands together for our awesome panelists.